In the name of Almighty Allah, the most merciful. In this second part, we are going to discuss the rights, duties, and liabilities of promoter. Mr. Abdul Rahman, please share with us the rights of promoters.
Sure.
Okay, sir. The following are the rights of the promoter. Preliminary expenses. A promoter is entitled to receive all the expenses incurred during registration of the company. The right is to claim expenses, not a contractual right. A promoter cannot sue the company to recover his expenses even if articles have provision for payment to preliminary expenses. It depends on the discretion of members of the company.
That's right. So as far as the preliminary expenses are concerned, the promoter cannot seek those expenses as a matter of right. This is not his legitimate right to seek that the company is liable to pay, and he cannot even take this claim on the basis of articles of association, because article of association and memorandum of association are the documents which are drafted by the promoter. So in order to avoid self conflict, or in order to avoid the conflict, this is given that the members of the company or the members of board of directors, they're not liable to pay those expenses, which are the preliminary expenses. And we use the word preliminary because these are the expenses which are incurred prior to incorporation of the company. So company is not incorporated. Company is not in a position to enter into a contract with promoter. So precisely, company has no contractual obligation or liability to pay anything even to the promoter prior to its incorporation, prior to its registration. So this is why preliminary expenses cannot be claimed by the promoter as a matter of right, because it is not the contractual obligation of the company to pay to the promoter. That was the first point. This case law is referred here. I'll skip that and move on to the second point, that is remuneration in terms of rights of the promoter. Mr. Abdul Rahman.
Remuneration. A promoter has a right to receive remuneration for his service. If there is no agreement to pay remuneration, the promoter is entitled to receive remuneration. If company makes an agreement with the promoter after its formation, the promoter can sue the company for remuneration.
Absolutely right. So here you can see that thin line, which is in fact appreciated by the legislator while drafting this corporate governance mechanism in our country, that is Companies Act 2017 and Corporate Governance Regulations 2009. That if there is an agreement between the promoter and the company, then of course company is liable to pay to the promoter in terms of remuneration. But if there is no agreement, and that is in terms of preliminary expenses, then of course the company is not duty bound to make that payment. So these 2 points, expenses and remuneration, we have discussed in terms of rights of the promoter. Now there are duties of the promoter. So let's see if Ms. Yusra is available to share the duties of the promoter with us. Yes, Mr. Fakhr, can you please share with us the duties of the promoter? Yes, Mr. Yahya Ijaz, can you read duties of the promoter? The promoter has following duties. So the secret profit is the first point. Mr. Yahya, please share with us.
Secret profit. A promoter is not entitled to make any secret profit for permanently contracts. If promoter makes any secret profit, the company may cancel the contract to cover the secret profit or sue the breach of duty.
Very right. So in fact, this is to discourage Mr. Yahya that the promoter actually who is there to enter into preliminary contracts prior to the incorporation of the company. So he's not allowed under the law to make any secret profit, in order to discourage him not to enter into preliminary contracts which are not in the best interest of the company, just to get kickbacks or secret profits. So the second part of this discussion relates with the disclosure of facts. Mr. Yahya, please continue.
Disclosure of facts. A promoter is bound to disclose all materials facts related to the formation of the company. A promoter must make complete disclosure of facts to the members. If he sells his own property to the company, he must disclose his interest in the contract to directors or shareholders.
Absolutely right. So there has to be absolute disclosure. Whatever facts, whatever information are available with the promoter, especially in terms of material facts, which are related to the formation of the company, and especially these material facts are brought to his knowledge while he was conceiving the business idea, while he was, in fact, at the second stage, while he was conducting investigation for the business. At that point in time, whatever material information he has gathered for the company, on behalf of the company, which is going to be incorporated, he is required to disclose all those information, and he cannot conceal, he cannot withhold those information, and especially the contracts he has entered into in terms of selling of property, buying of property, any rental agreements, whatever material facts he has in his knowledge, he is duty bound to disclose. Now, with this discussion, the three basic areas: rights of the promoter, the duties of the promoter, and now comes the liabilities of the promoter. Section numbers 92 and 93 of the Securities Act define liabilities of promoter in the following terms, and these includes criminal liability. First of all, Ms. Yusra, please share this first point with the participants. I'm afraid we can't hear Ms. Yusra at the moment. Criminal liability: promoter commits an offense and he becomes criminally liable if these points are given here. Mr. Fakhr, please share these points with us.
Yes, sir. A promoter commits an offense and becomes criminally liable if he makes a misleading or untrue statement in a prospectus. He omits information from a prospectus that the law requires to be included in the prospectus.
Absolutely right. So he will be criminally liable. He will be punished under the law. He can be fined. He can be fined. He can be granted punishment if he, number one, he has made any misleading and untrue statement in the prospectus in order to, attract investors for his company, and he has issued a prospectus and he has made misleading statements in the prospectus regarding the company, or he has made some untrue statement and he is trying to attract investors on the basis of false and frivolous information, then of course he is criminally liable for that. And furthermore, if he has in fact omitted certain information from the prospectus, he has omitted certain material facts that otherwise law requires him to disclose to the investors, and he has deliberately omitted those facts, then he is criminally liable to pay the compensation. So the compensation is the last point. And let me request Mr. Abdul Rahman to share this point with the audience.
Yes, sir. If promoter has signed the prospectus, he shall be liable to pay compensation to any person who acquires securities depending on the prospectus containing any untrue or misleading statement.
Absolutely right. So he is liable to pay the compensation, and he will be personally liable actually if he has committed these acts, or he has made untrue statements in the prospectus, or he has shared misleading, incorrect, false, and frivolous information, then he is criminally liable for that. Before I conclude this discussion, I'd like to invite questions. Well, it appears that the points discussed in terms of rights, duties and liabilities of a promoter are self-explanatory. And with these words, I thank you, the participants, for their active participation. Thank you very much.